Hello, my name is Jubin with Dana Legal Services, and in this video today we're going to talk a little bit about what you can do when it comes to filing your patent application in terms of the various options that you have. Recently, one of my clients asked me, well, what's the advantage of filing a provisional patent application versus a non-provisional patent application if we're putting the same effort into writing those two applications up? So I would say this, when you look at a patent application, whether it's provisional or non-provisional, the part of the application that describes your invention and the figures that go with that is probably where the attorney will spend the majority of his or her time preparing your application. Now, if you're filing a provisional, people think that's a lower cost application. Well, it kind of depends. If you spend less time writing it up and put fewer figures, well, of course, it's going to cost you less because it's taking less time for the attorney to do it. However, if you want to do this correctly, if you want to file a provisional application that you can then later convert to a non-provisional application, then what you need to do is make sure your provisional application covers your invention completely and fully. As a result of that, your attorney will spend a certain amount of time preparing that provisional application. Let's say it takes the attorney 10 hours to prepare your provisional application. If the attorney is going to also prepare the non-provisional application, then they will probably add, in addition to that 10 hours, about 3 hours or so, maybe 4 hours, drafting your claims. So a non-provisional application will have the expense of drafting the description with the figures, plus the cost of doing claims. Provisional applications don't require claims, so the attorney doesn't have to spend that time. So there is that cost savings. Then the other cost saving is, of course, in terms of the filing fees. The provisional application is about $200 to file. A non-provisional application is more like $900 to file, assuming you are a small entity. And given that we work a lot with early stage companies or startup companies, then we typically use those two fees. If you want to know what those fees are for a large entity, then you just double those costs. Once you file your provisional, you have then 1 year to convert it to a non-provisional. If you file a non-provisional, you're already at the stage where the case is going to get examined. Remember, we have another video that explains this, but provisional applications never get examined. So they expire after 1 year. Whereas a non-provisional application will get examined, someone will look at it, and as a result of that, you'll know whether or not you can have a patent. So you'll get an office action. We also have a video that explains what happens when you get your patent application examined. Take a look at that video. It'll be listed down below. Overall, what we're looking at is the cost of preparing the provisional versus the cost of preparing the non-provisional is about a difference of about 25% in time for the attorney. The attorney will spend the majority of the time describing the invention with the figures. For the non-provisional, they'll also have some more time they spend on drafting the claims. Whereas for a provisional, they just put a simple little claim at the end. They don't need to spend too much time on it because the case is never examined and the claims are not required. That, in a nutshell, sums up your options. Now, there are various other things you can do. Give us a call. We can discuss all your options with you. My name is Jubin Dana with Dana Legal Services. Here's our contact info. Take care.